as everybody knows by now, these chats kind of build up, and we'll have guests come at whenever time they're available. So people will join us, and they'll offer their analysis and takes, and as best we can, we'll try to break down what's going on in the trial as best as we know. But as MB just pointed out, I mean, it's a real problem to try to do this over Twitter. And I thought the first day when everybody was live tweeting, the trial seemed really, really good. But then we found Leslie, who put out just a huge and awesome tweet thread, who actually attended the trial. And after reading that, I felt like the first day maybe wasn't that good. She described it as really disorganized, which was pretty disheartening to see. But then I think it was the last 2 days, or certainly yesterday, I really had the sense of, oh, this is not going well. And that kind of coincided with these long gaps in the live tweeting. And then, I think everybody kind of had that feeling yesterday where, okay, there's not much happening. That must mean the trial's not going well. But then when we got the transcripts of yesterday, in my mind, the Durham team did really, really well. And then today, so obviously I have the benefit of just seeing most of the transcript through this YouTube train. Durham team did really, really well today. They definitely prepared for Baker's testimony. They prepped him really, really well. And yeah, they crushed it today. I mean, Baker coming out and saying he's 100% confident that Sussman lied verbally to him in that meeting, which is the basis of the charge that he faces. That's huge. I mean, that's okay. So now the lie is really not in question. I mean, they're gonna bring in Bill Priestap and Trisha Anderson, who took notes contemporaneously on that day after talking to Baker, where they note in addition that Sussman said he was not there representing the client. Yesterday, they introduced the text message, which was actually the day before, where it's clear as day. Sussman said he was not representing the client. So that's really not in question. We didn't think it would be even before the trial. Sussman definitely lied. And what also came in today, I thought Baker was a really good witness for Durham. There was several statements that went to the heart of materiality. Baker said at one point, if he had known that this was Clinton or Joffe or the DNC was behind this, he would not have taken that meeting with Sussman at all, and he would not have taken all these steps that he took. So that's huge. That goes right to the heart of materiality. MB, I don't know if you have any thoughts. I'm going to add Ship as speaker to get his thoughts as well. But
Yeah,
MB, go ahead.
I agree 100%. I think we all were really worried about Baker because he's been, anything from a bad actor in this to at best just kind of like haphazard. And the fact that he came out and just really laid it down and said things very authoritatively and confidently that we thought he might be mealy-mouthed about is huge for the case. And I think it was Margot Cleveland that said, and if it wasn't, forgive me, whoever I'm misquoting, but said if he could look like a better witness because he's friends with Sussman, because he's got no beef with him, that he sounds a lot more believable because he doesn't have an axe to grind or any political thing, anything like that. That makes what he's saying all the more believable.
Yeah. Hey, Ship, I see you just accepted to be speaker. I don't know if you want to jump in with any thoughts that you had from today.
What happened today?
Yeah.
No, it's tough to follow when all you really are looking at is Twitter feeds. I saw, you're captive to the emotions of the writer, unfortunately. And so a little bit, of a grain of salt with some of this, but, I found like 5 or 6 different reporters who are following it. And nobody, though, matches what, Leslie McAdoo Gordon did back on her first day, I think Wednesday, when she was there all day, but she couldn't get back, or maybe Tuesday. I have kind of mixed emotions about the approach that Sussman has taken overall. I didn't like the way they started. And it's like, if it's my case, I just start with Crossfire Hurricane. What was the FBI doing when these materials showed up on their doorstep, courtesy of Sussman? They were investigating Trump and Russia. That would have been the foundation for me for why they were material. An FBI agent in there explaining what had started in June or July, leading up to what Sussman did in September. Why they started with technical agents and DNS lookup shit, I have no idea. Just, it's like,
Chip, I think you cut out
Baker
there.
today. Yeah, I mean, if you just go based on the tweets that were written about Baker's testimony, it pretty did, it did pretty well bullseye the materiality issue. I would have acted differently. Well, two things he did. He said, absolutely, he told me he was not there for a client. He said just categorically, even though he'd had various versions of that in different circumstances, he explained a couple of them away, saying he didn't anticipate the question when he was asked by Congress, and that's why he was uncertain of his answer then and didn't recall, and that later on he was able to refresh his recollection by reviewing documents and whatnot. So he was dead certain, and I think probably that text from the night before kind of stands out, because why do you make that representation? Why does Sussman go out of his way? Why does Sussman go out of his way to make that declarative representation in a text and then not follow it up and say the same thing the next day? So Baker, clearly said he followed it up and said the same thing the next day, reinforcing in my mind, Baker, that he's there just to, assist the FBI and report information that he's come across, not representing any client. And then, as others said, he came back later on to clearly say, had he said that in the text, or had he said that at the meeting, my actions would have been different. My reaction to the information would have been different. I would have treated it differently. I would have handled it differently. So yeah, on those two grounds, what they got out of Baker was good.
MB, did you have anything else?
Maybe Chip can talk a little bit about the motion for the mistrial, because I think a lot of people are confused because something came up in the court listener that scared everybody.
Yeah, what happened, as I understand just from the reporting, is that at various points yesterday, Mark Elias, being a bonehead and not a trial lawyer, in response to a defense question initially about did Mr. Sussman blah blah blah, was Mr. Sussman blah blah blah, Elias's response was, well, you'd have to ask him. Well, that implicates or makes a suggestion as to the defendant should testify. When a defendant in a criminal case has a Fifth Amendment right not to testify, and that subject is not supposed to be commented on by anybody. And Elias should know better than that, although I'm not confident that he does, because I actually don't really think that much of him as a lawyer. So he said it first in response to a defense question. And then, and somehow there was an argument made that he repeated a similar kind of, well, you'd have to ask him, or he could tell you, something like that, in response to a question on redirect. And so at the end of the day, the defense lawyers made the point that, they might be seeking a mistrial because of the improper reference to a defendant, having an obligation to assist the jury by testifying. And I guess overnight they filed a 5-page memorandum asking for a mistrial, which Cooper denied this morning, although he struck Elias's non-responsive comments, not responsive to the question from the record. And I initially, my first comment was, well, why would you ask for mistrial if you like the jury or if you like the way the case is going so far? Generally, defendants start looking for mistrials when they're unhappy with the jury or the way the case is going. And then somebody else jumped in and said, well, sometimes you have to ask for a mistrial in order to preserve your record for appeal. If you don't ask for a mistrial right there, you might have waived the issue for appeal. I'd have to, do some legal research to see if that was an accurate assessment or not. I can't say off the top of my head whether asking for mistrial was a necessity in order to preserve the issue for appeal.
Hey, Cody, what's up, man?
Hey, what's up? Came in late, so can you recap like the first couple minutes for us?
Yeah, I went ahead and plugged Rob Govea, who does just outstanding legal analysis. He has a YouTube channel. He's going to be analyzing everything um, every day of the trial. So he had like 2.5 hours of video where he broke down yesterday's transcript and today's transcript, um, really line by line, important section by important section. And he was still going when we started this chat. So he's going to be great for everybody that. And then we kind of talked about Baker today. I mean, so I thought Baker was really, really strong for Durham. And I think I also talked a little bit about, what Ship just alluded to, in that it's really hard to get a sense of the trial and how it's going from these live tweets. Like day one, everybody thought it was like really, really strong based on the tweets. And then Leslie McAdoo Gordon wrote out this really long tweet thread with brilliant analysis, and she picked up some things that everybody else didn't, and it seemed a lot more disorganized from Durham on day one, which was pretty disheartening. But then on day two, like yesterday, I think it was, uh, people weren't live tweeting as much, and maybe it was just because of that. But whatever the case, like it felt like it was a really bad day for Durham. But then when you got the actual transcript, I thought Durham had a much stronger case yesterday. And then being able to go through the transcript today, I thought Durham was doing really well. And obviously Baker was a strong witness. I mean, coming out and saying he's 100% confident that Sussman reiterated that he was there not on behalf of any client. I mean, that's huge because there was all these stories about how Baker was flip flopping or he wasn't really sure. So he came out today and he said he's 100% confident. Sussman told him that, no question about it. And then he also got into materiality a bit, and he said, explicitly, if I had known the truth, if he had told me he was there on behalf of Clinton or the DNC or Joffe, I would have treated it differently. I would not have taken the meeting, I think he said at one point, and he also would have briefed the others differently too, and maybe they would have asked more questions. So I thought that was huge. I mean, I didn't really expect to get that out of Baker. But now we're going to get into Trish Anderson. We're going to get into Bill Priestap, and those notes have already been discussed a little bit. But they're gonna testify, and their notes, taken contemporaneously, are adding another layer to this. So the lie is really not in question at all. It's all going to be about materiality, and I thought it was huge today to have him on the stand saying, "I would have taken different decisions. I would have taken different steps as the general counsel of the FBI, as the assistant director at the FBI." Um, how can you come back on the defense side and say, "Well, no, it wasn't material"? Like, don't listen to what this guy is saying. He's like a senior executive of the FBI, and his decisions would have changed. But don't listen to that. The statements were not material. Like, that's going to be really challenging for the defense, I think. Did you have anything else, Cody or Ship? I don't know if you have any other thoughts from today.
Yeah, no, other than could you post the link to? Oh, this Robert Govea Esquire has the transcripts.
Yes. Yep.
Yeah. Okay, I see that. Okay, I see that now. Because not that I really want to take on reading a day's worth of transcripts. I've got enough other stuff to do, but I'll be interesting just to glance through them to see what jumps out at me. I've read a few transcripts in my day. I just the point that Leslie made in her initial tweet string, I think it was on Tuesday. Yeah, because they picked the jury on Monday and they started testimony on Tuesday. and it was a very good observation that I think is underappreciated, is that, you know, this is not a case where Durham has many, if more than a small handful of friendly witnesses. The entire case is built on hostile, or what you might consider quasi-hostile witnesses, people that have some sympathy or loyalty or kinship with Michael Sussman because of the connections at DOJ. Um, and so he's going to have, and I think some, other than the early two FBI witnesses, he's going to have some witness control issues. When you're trying to build a case by getting, helpful information from somebody like Mark Elias or Laura Sago. For all the discussion about Laura Sago leading into yesterday, I didn't see where her testimony did much of anything. Now, so that tends to make for a very uneven presentation of evidence, and in my mind, it even calls out even more for a much better start, a solid start that gets you on solid ground going forward, where you don't have to worry about that. They had to jump so quickly to quasi-hostile witnesses. Now, another way to look at that is you get those quasi-hostile witnesses out of the way in day 2, and then when you're wrapping up your case in day 4 or day 5, which I can't believe it's going to take them too much more than that. Those quasi-hostile witnesses are far enough in the rearview mirror that the jury doesn't really remember them that well.
One section that I found really important, really unrelated to the specific trial, I just tweeted it out, but it's this section where Sussman actually brought the names of 3 cybersecurity researchers who supported this allegation, or something to that effect. The exact wording we don't really have exactly what Sussman was alleging or alluding to, but basically he brought 3 names: Matt Blaze, Stephen Belvin, and Susan Landau. And 2 of those would later be quoted in articles about the Alpha Bank server allegations. But Sussman brought those names to Baker in September 2020, or excuse me, 2016. So that really hints to me that those 3 people had prior knowledge of that, or they would at least obviously be familiar with the allegations, but also that Sussman would be bringing them to the FBI, because if you give the FBI 3 names, the first thing the FBI might do, you have to anticipate, would be to reach out to one of those 3 people. So you wouldn't want them to be blindsided, and to have that it's not confirmation, but that strong indication that this might be a little bit broader than at least I personally was thinking. I thought that's pretty interesting. Ship, I don't know if you want to talk about. I think one of the questions that I see most in my DMs right now is, jumping ahead a little bit. If Sussman is convicted on this charge, or let's say even if he's acquitted, how do you see that really impacting a broader, wider case that Durham might be pursuing?
Well, to be, frank, at this point, the fact that Mark Elias took the stand and testified, to me, is almost a death knell of a broader case. I didn't see how a broader case would not involve him. He's the link between the private actors and the campaign. And potentially, between the campaign and the FBI, working with Sussman. The fact that he took the stand and testified means he's got no Fifth Amendment need. Nobody made a reference to him having been given immunity, and so that just leads me to conclude that he's been told by Durham that he's not a target. And if he's not a target, then who else could be a target? I mean, I've kind of assumed for a long time that the public actors, the people in the FBI, are not ultimately going to be targeted for criminal prosecution. And if so Jaffe conceivably, but how do you get a broader case that pivots off of a Sussman conviction, potentially with Sussman cooperation, that doesn't include Mark Elias? So I'm scratching my head. I had always assumed there was a broader case out there, and this was just a means. This case was a means to an end, but I'm not so convinced of that anymore.
That's interesting. I mean, Elias is obviously a prosecution witness, but he was not friendly. I mean, there's no indication that he got a deal with immunity. But I also had sort of the same thought with Laura Seago. For somebody that got immunity, they really didn't get anything from her yesterday. I know you kind of made the point earlier, but to give somebody immunity and then bring him in, and there's really nothing that she said that was really central to the case or that seemed ultra necessary. She did testify to a certain meeting that she was a part of where Sussman, Elias, and Jaffe were present. So maybe maybe that's it. I mean, I'd hate to think that alone was the basis to give her immunity just to get that point in. That would seem to suggest that Durham's really reaching and really scraping together a case.
Yeah, and I mean that was I had always assumed that was a meeting that they wanted the testimony about what was said in the meeting. If there was something said in the meeting that was, inculpatory, and that they couldn't get it from Sussman because he was a defense lawyer. They couldn't get it from Jaffe because he's going to assert the fifth, and I assumed they couldn't get it from Elias because he was going to assert the fifth, but Elias didn't, and then her testimony didn't really even cover the substance of what that meeting was or anything, that implicated others in a criminal conspiracy, during the course of that meeting. Maybe there's more there. Maybe she's given them more information they just didn't think they needed in this particular trial, so it didn't come out. And, the defense didn't want to touch it, so they left it alone. It's hard to know. But I had assumed that they gave her immunity to get her testimony about that meeting because none of the other three participants would testify, and then Elias gets on the stand and testifies.
I guess I've also seen a lot of hand-wringing from, a lot of commenters on Twitter especially, saying, well, it's a D.C. jury and, the judge is letting some of these people sit on the jury, or these other tangential issues are kind of not going in Durham's favor. But, I mean, to my mind, this is actually a pretty simple case, and it's very much winnable. And Ship, I'll ask you to get your thoughts, but I mean, it's just a false statement case. I mean, for all the noise about all these different elements and pieces to it, this is just a false statement case. And for that, Durham has to show that Sussman lied, and he's done that. And he has to show the lie was material. And as we noted earlier, Baker's testimony today was important for both of those, stating that he would make different decisions. That is the essence of materiality. And it doesn't actually have to change a decision. I mean, it just has to have the capacity to change a decision for a reasonable person. So, if they had known that the clients were the Clintons and Jaffe, I think everybody would nod their heads and say, well, yeah, that could change some decisions, especially when the FBI's general counsel is on the stand saying, yes, it would have changed decisions. So, I mean, Ship, do you have any thoughts? Do you think this is heading towards a conviction, or, is there a high likelihood of an acquittal to your mind, or do you have any thoughts on that?
I mean, I have, I have suspected it's headed for a hung jury. I just don't think, you're going to get 12 jurors in the district to convict. I think there'll be enough sentiment in the jury room that that the FBI did the right thing. Sussman gave him information, and it was all done right, and that it should have been investigated. And I don't think Durham's going to be allowed to get into deeply enough the idea that this information was all faked. I think he really needed that second element, that not only was Sussman deceptive by providing the information and omitting his client, Durham needed or needs to be able to tell the jury that it was done in a corrupt fashion because the information was spoofed and Sussman knew it was spoofed. Now, whether the evidence takes him that far or not, I don't know. I suspect Sussman knew it was faked. It was ginned up to look like something that it was not, which the FBI quickly unraveled. The FBI said it took us a day, less than a day. I knew after looking at it for a couple hours that it was not what was represented to be. Okay, so then the question is, well, was it just a good faith error? And I think if allowed to do so, and not going to be, Sussman could put, or Durham could put, experts on the stand to say, no reputable DNS expert would have thought this data reflected what was claimed in the white papers. Any reputable DNS expert would have known that what was claimed in the white papers was a radical exaggeration of what the data showed, which only leads to the conclusion that the white papers were purposely misleading.
Durham obviously can't attack that directly, but I thought it was really important to have, I think it was Hellman, take the stand, and he debunked it within a day is basically what he testified to. He was able to take a look at it, and within a couple of hours, he knew it didn't support the narrative that he was given. And there was issues with the data. And I know there's going to be more testimony from the CIA, I think probably tomorrow, that's sort of in that same vein, that the data was user-created. I think Durham's been given leave to present the findings or the conclusions that the CIA had. So he can't attack it fully like you would want, but I think the jury might get enough to know, or at least have the questions, okay, it is fake, and maybe they won't be able to connect that directly to Sussman, but it will damage, I think, the defense's ability to pivot off that and say, well, he was just a good citizen, and he obviously, he wouldn't have known that it was spoofed. And I thought Baker had an important line today, because Baker actually said something to the effect of, well, he's not a personal injury lawyer. He was referencing the fact that he's a cybersecurity lawyer who represented the DNC in the hack of the DNC matter, because he is technically savvy and he does have at least a certain skill set in working in the cybersecurity practice, that he knows a lot of these concepts and he has some idea of what he might be looking at. Daniel, I just had you a speaker. I don't know if you have a question or comment. Go ahead, man.
Hey, man. Yeah, I was waiting for you to finish. I just had a question for, I think, Ship. Mostly about what what you guys were talking about with Laura Seago and Elias's testimony, especially about something that jumped out to me was in Elias's he testified about a 3-hour meeting that they had with Sussman, and they worked on a white paper, I think. And he said he just doesn't recall it. And that's like with Laura Seago, she just doesn't recall it. I don't think that Durham has the evidence right now that they do remember, or that something happens. He can't get it out of Laura Seago. She says she can't remember. And that seems like his last avenue to get like those things in that specific meetings. So I think yeah, I don't know.
Well, one thing we haven't seen yet, or at least not to the extent that you can tell from the tweeting.
Sorry, my mom just walked into my room.
one thing we haven't seen yet, based on the tweeting, is a government witness who is going to essentially get into the record writings by Sussman. Emails, text messages, correspondence, billings. I saw a reference, I think, yesterday. Marcy Wheeler said, "Oh, Sussman's going to use a paralegal and destroy the paralegal's career as a summary witness." I don't even think she knows what a summary witness is. But somebody's got to get on the stand. I guess you could use a paralegal. I would always use an agent and say, go through. You might have 100 exhibits that the defendant wrote, and they're all admissible because the defendant's statements are not hearsay. And you go through them one at a time, and you have them admitted. You have marked, identified, and admitted, and then published for the jury. And then the agent can testify about what is. When we say published for the jury, that means it's put up on electronic screens for the jury to read in real time, right, during the trial. It's not like they have to wait until they're deliberating to be able to read the contents of written documents. The documents are put up on video screens for them to see, and then you can use various electronic tools to highlight certain parts of the text, and the witness can sit there and just read from the text. Now, some judges don't like to have a lot of that. It's like, we're not going to waste time reading it. The jury will be able to read it when they deliberate. But I've seen some judges just allow hours upon hours of testimony, which is nothing more than the witness reading the text of written documents that have been admitted into evidence. And I've got to believe there's a lot of that coming, to establish probably, the existence of an attorney-client relationship, and that Sussman was, in fact, acting on behalf of the campaign, and his communications with the campaign prove that. What else is going to be in those writings? That's kind of the $64 question. What other substantive information about this kind of conspiratorial arrangement that Sussman was involved in with members of the campaign staff and others? What kind of or Fusion GPS? What kind of things did they admit to in communication between each other that they never imagined would be read in an open court before a jury? That's always the fun part.
I have sort of a question that leads right into that. And so MB actually posted, I think earlier today, some of Sussman's congressional testimony where he states categorically that he was there on behalf of a client. Considering or taking into account the fact that Sussman, can't be forced to testify, how is Durham able to explore that testimony that Sussman gave in Congress in this trial? And I was thinking, one of the things he could do is just have somebody on the stand read that testimony. But how is the jury able to see the significance of it?
Well, that's exactly where you get it on. You just have a witness identify the exhibit. It's a transcript from a congressional proceeding. It can be, I don't know, it's probably going to be a self-authenticating transcript. It'll probably be an official certified copy of whatever was produced by the court reporter that did the transcription. It'll have an affirmation or oath page on it that it was testified to under oath, and so it's self-authenticating. You don't need to have a witness testify about what it is. And I had used any number of transcripts in trial where I would read, if it's a two-party exchange, questioner and a witness, question answer, I would read the questions if I was the questioner as the prosecutor, and the witness would read the answers as Sussman. And it would be just as if Sussman was testifying right there in court based upon what he had said under oath in the proceedings before Congress. And the jury would listen to it. And then, the significance of it is essentially, that's what closing argument is for, is to draw the jury's attention to evidence that they heard that maybe they didn't understand where it fit at the time they heard it, but the job of the attorney giving the closing argument is to make the pieces fit together, to bring the various aspects of the testimony and the evidence into focus and show how they fit with one another to tell the story.
Hey, FOIA fan, how's it going?
It's going busy, going busy. I just popped in to say hi and see who was here. I missed the trial today, so I have nothing to contribute.
Okay. Well, see, we have a question. I'll start taking some questions, but yeah, FOIA fan, I like that idea that you had earlier in DMs. We should definitely set up a chat sometime.
Okay, well that I can mention is that
Okay.
that UNDeadFOIA and I were bouncing back and forth the idea today of maybe having a spaces sometime in the future on the subject of FOIA reform and invite certain uh, people in Congress, their staff, anyone who's running or anyone who's interested in the subject, because obviously our FOIA system is broken. It's pathetic what we have to do to try to get our hands on documents that are supposed to be public and that are supposed to be freely made available to the public. They, especially on the federal level, if it's anything that's at all of a political hot potato, they delay it for years. They redact the living heck out of it, and they come up with every excuse not to produce things. It's pretty pathetic in a country that has a statute that's called the Freedom of Information Act. But that's a subject for another day.
Yeah, I can't agree more strongly. I mean, probably 90% of my FOIAs have been at the federal level, and to this day, I have had zero FOIAs processed at the federal level. Every every FOIA document I've gotten has come from a state agency or a university or something like that. So I don't even know how many FOIAs it is. Probably 120, 130 FOIAs probably at the federal level, and zero. Not a single one has been processed, which is just insane.
Let me mention this. It would be hard for me to imagine, as somebody who worked 22 years in the Department of Justice, it would be hard for me to imagine a worse job in the federal government than having to respond to FOIA requests. It's just like, to me, it would be a mind-numbing process.
I I don't disagree with that, but I mean, it seems like all they're doing is cutting and pasting a rejection level, and then I don't know, spend the rest of their time ordering pizza or something. Because
Yeah, 90% of the time is writing letters telling you how long it's going to be to get anything, and 10% is actually going through and just redacting documents and putting B5, C2A over the redactions.
I I swear, every time I get a rejection form, it's like they just did like a random exemption generator or something. Like it doesn't make any sense. They just throw up any exemption they feel like. But yeah, FOIA fan, I can't wait to do that chat, and hopefully we get a nice crowd for that one, because it's way overdue. We need some reform there. Um, hey Robin, I see you are a speaker. I don't know if you have a question or comment. Go ahead though.
Hi. Yeah, I do. It goes back to Laura Sego, and I was really disappointed that, like some of you have talked about, how it didn't seem like she did a lot. But I think it's because we aren't privy to, well, we didn't obviously get to see or hear the testimony, but even getting a transcript is kind of difficult. And I did get a copy of her testimony. Basically, I think it was from the guy on the YouTube. He has on his mind map or his map thing. He has a link to the testimony there, or to the transcripts, I should say. Anyway, I was reading, and she actually, testified to saying Elias was her main contact about all of this. So she named Elias, and she named all of the guys that are, Sussman, Elias, Jaffe, and I don't know what was the fourth one. There was a fourth one. But anyway, I'm just wondering, will they bring her back at any point? Or is that it for this trial? I know you guys had already talked about that. But because we can't see until you actually start reading the transcript. I mean, there's more in the transcript than obviously was on the Twitter feeds, which was so disappointing. Oh, but yeah. So I'm just curious. Do you know if she could be brought back at any point in this trial?
Generally, a witness is either released or subject to recall because the witness is there in response to a subpoena. So at the end of their testimony, a judge will ask both sides anything further for the witness. And if both sides believe that they're done, that there's nothing more in this case that they want, then they'll just, advise the judge the witness can be released, meaning the witness can go back home, wherever they came from, because many of the witnesses are probably from out of town. But sometimes you'll say, I'd like to have the witness reserved to be recalled later in the case. And then the judge will say, if the judge agrees, most of the time they do, the judge will say, okay, well, you're subject to recall, so whatever hotel you're in, go back there and wait for somebody to call.
And would that be addressed in the transcript? Would that be stated there?
Usually it's right on the record there at the end of the witness's testimony.
Okay, I'll have to look for that then. Yeah, okay. Because it just seemed like, for some reason, it didn't seem like, well, as far as I've read so far, it doesn't seem like the prosecution really asked. Well, she said she didn't recall what was really discussed, except that they were dealing with Trump, bad things about Trump, and then, the Alpha Bank thing. So that's all she said. But they didn't get anything like, a discussion point or anything from that. And I was just like, that's, I guess, what I was hoping for. And so I'm wondering maybe that might come up later, but maybe not. All right. Sorry. Thanks. That's all I have.
Yeah, no, it's a good question. And we kind of talked a little bit about that earlier. I mean, Durham gave Laura Segal immunity, and it doesn't seem like he got a whole lot out of her testimony other than perhaps mentioning very briefly just this meeting that occurred between herself, Sussman, Elias, and Joffe. And, Ship brought up the point earlier. I mean, they didn't even get into the conversation that was had at that meeting. They just basically left it wide open, and I think they described it very generally as relating to the Alpha Bank allegations. So, yeah, it is a little bit unusual, but we'll see if she pops up further down the road, maybe in other trials or what the case might be.
One of the things, to circle back to Elias, he just seems so comfortable with himself and brazen, and like he didn't have a care in the world that he had any kind of liability or danger going on. And he, the fact that he said, not only did I not know that Sussman took these documents or didn't approve of him bringing them to the FBI, I wouldn't have wanted him to, because we didn't want the FBI to have them, because that would slow things down. Well, at the same time, they're moving heaven and earth to push the Steele dossier to the FBI. So Elias is just full of shit, and he's just brazenly saying this stuff, and that's more worrisome than anything.
I think that's spot on. And to some extent, I really like the fact that Durham has this trial going on right now, and some of these witnesses are being locked into testimony. And I don't know if Elias is going to be prosecuted or the subject of any investigation, but I mean, to have him on record now, obviously he testified before the grand jury, but this sort of adds to it. And there's a few statements that he's mentioned that are lies. Like, we might not have the evidence to say that they are lies conclusively, but there's no doubt in my mind. I mean, he's lying, right? And I don't know, is there a single text message out there that Durham's going to find someday, or is he going to flip a witness one day? And are these statements going to come back as perjury charges for Elias? I think that'd be ideal, right? Does anybody else have any questions or anything? If you want to ask a question or if you have a comment, you can request to speak. I'll keep this open for a little bit. We try to do these as often as we can. I'm certainly planning on doing one on Monday. So I'm heading out to Washington, D.C. this weekend. I'll be at the trial. I'm planning Monday through Wednesday, and I'll probably host chats every night, Monday through Wednesday for sure, because I'll actually be able to see the people and sit in the trial. And if I happen to pick up something that people are tweeting out that or didn't tweet out, then I'll be able to talk about that. So let's see here. Hey, Rough Cut, what's up, man? I'm sorry, Rough Cut, what's up? Okay. Let's go to JH. What's up, man?
Oh, can you?
I guess the quick question question / comment is, I kind of get the feeling that Seago was given immunity, to testify, and then Judge Cooper sort of limited all the possibilities to which she could testify to, and so that their great witness was sort of neutered by the judge, after she was put forward as a witness. So I don't know if that's the case or not, but it kind of seems that way to me.
That is a good point. So she was originally, I think, put on the witness list and kind of introduced into all this as Durham was going to try to pursue this, this greater conspiracy joint venture theory that he was going to present at trial, which involved Fusion GPS, Rodney Joffe, and others. And in that case, she might have been more useful. So that's a good point.
Hey guys, this is Rough Cut. Sorry, I was on mute.
No problem. What's up, man?
Hey guys, like I said, I appreciate you guys doing this. It's pretty awesome to be able to talk about these things and kind of get perspectives. So with Elias and some others, so many of these folks that perpetuated this lie and this scheme are lawyers. And even though Sussman may or may not be found guilty, hopefully guilty, is there any cause, just like Elias has done with lawyers that are representing people, for January 6th and things along that line, is there any cause for anybody to go after his law license and the others that are lawyers for kind of perpetuating this, even though a guilty, they may not be found guilty, just based on the profession, conduct and things along that line? Thanks.
Yeah, that's a great question for Ship. I don't know if he wants to comment on that, but it seems like they could face sanctions or at least ethics investigations, even if they're not criminally responsible.
Yeah, I mean, they are advocating on behalf of a client. If Sussman, if a bar complaint is made on the basis that he knowingly took false information to the FBI for the purpose of causing the FBI to initiate a criminal investigation, it's an actionable claim. A bar association would probably, if sustained, if factually accurate, the bar association would take, dim view of that, and regardless, well, I guess I shouldn't say that. The outcome of the case will have a big impact on, Sussman's legacy as an attorney going forward. It will, if he's convicted, it will, do great damage to his reputation, which was decent in terms of in the narrow area of specialty that he occupied with a significant government provided expertise as a cybersecurity specialist in sort of the early days of that area of criminal specialty. I can remember I thought about jumping to cyber back in after 9/11 and national security and cyber and looked into it. And I didn't have a technical background, so kind of weighed against me. They really were looking for prosecutors who had some kind of computer or engineering background and not have to learn everything from basic forward. And he had that. I don't know what his background was, but he did venture off into that specialty area and obtained a great amount of expertise, which he was then able to take with him into private practice and gave him some credibility and some cachet in the business. And that will be greatly tarnished. And he was let go by Perkins Coie and would likely have a hard time finding, even if he doesn't lose his license, a la Kevin Kleinsmith, he'll likely have a hard time finding, a top flight law firm that would take him. Elias has had to go out and start his own. Um, so, all of that remains to be seen. Whether others, he's the only one right now accused of a crime. So his conviction would be, the event that might precipitate some form of action against his license. At this point, others would just simply have to have bar complaints filed against them for, allegations of misconduct short of criminal activity, unless Durham chooses to, charge more people.
Good stuff. Hey, Daniel, what's up, man?
Yeah, I saw another question, I guess. I read that Laura Sega's immunity was trial immunity. So does that mean that Durham hasn't deposed her or interviewed her now without her asserting her Fifth Amendment right? Or is he going to get any of that? Or is it just what she testified at trials? That's all it's going to be. That's trial immunity. I don't know. Just wondering for Ship.
Yeah, I'd have to see her agreement to see if she got transactional immunity or use immunity.
Yeah, I think it was use immunity, it looked like, so I thought that was interesting.
Yeah, and so that's more limited. She could still potentially face exposure if Durham had, independent evidence untainted by her testimony, which is protected. But
yeah, so it was
I
notable. He wasn't able to get her to waive her Fifth Amendment then fully.
Yeah. So there would be limits, and again, it's all dictated by the paperwork, and without reading the paperwork, I really couldn't say.
Thank you.
Honestly, I'd like if anybody. I mean, I see some familiar names on here, people that I'm sure have interesting perspectives to offer based upon, what they have read and listened to over time, and now what they're seeing and hearing in the trial. I think everybody's heard quite enough from me over the last several weeks doing these, so I'm curious to hear from others.
Yeah, let's take a few more questions. We'll try to give Ship a break. Hey, Kimmers, what's up? Let's see here. Kimmers, I believe your name is. If you have a question or comment, go ahead. Uh-oh. Lost her. All right, let's see what else we got here. Buff,
Yeah, how you
what's
doing?
up?
My question is, after these proceedings, win or lose, what happens to special counsel? That's all I got. Thank you.
Yeah, special counsel Durham's still going to go. He's still got an active criminal investigation that he's pursuing. We don't know when that'll actually end. It'll end whenever Durham says it's done. So beyond that, we still have a trial for Igor Danchenko. I believe that's still scheduled in October. So that'll be the next time we hear from Durham for sure. But yeah, he's still investigating everything that happened, and based on what I've seen, I wouldn't be surprised if he's still got another year or two to go.
Thank you.
Hello. Hi.
Yeah.
This is Kim. I keep getting my mic turned off, and I figured it out, I think. Anyway, I have a question that kind of goes back to yesterday's or day before yesterday's conversation that y'all had. And Hans had said something that the way Durham has set this whole case up is that, Sussman and everybody duped our FBI, and the FBI is the good guys. So that's going to set things up for later trials, that we can't go after the guys in the FBI that did do something wrong. Is that true? Or can we turn around and say, that these guys, they were part of the conspiracy. They were part of it too. And look, I just don't see how we cannot let the people that were doing the wrong things within the FBI get away with this. This is what I'm just dumbfounded by.
Yeah. So Hans is obviously brilliant, and he's been looking at this for a long time. But on this one, I think I disagree a little bit. I think generally speaking, people that have been following this, kind of in this corner, if you will, are moving away from the idea that members of the FBI or the Obama administration or State Department will be prosecuted. I think we're all moving away from that. But I'm not quite ready to rule it out yet. And from the standpoint of his comment that the FBI is being set up as the victim, that's true, but it's not dispositive for, I guess, their ability to be prosecuted later. Like, if they're a victim here, that doesn't rule out the idea that they could face criminal liability themselves. But as an institution, they are a victim in that they received false, manipulated, fabricated data. In this case, and the Steele dossier was obviously fabricated too. So in that sense, you could say, well, yes, the FBI is a victim. But the challenge, and I think it was Schiff that pointed this out. The challenge becomes, if you want to hold them criminally liable, barrier number one is that they did receive fabricated data. In this case, in the Alpha Bank, but also fabricated from the Steele dossier. So that's barrier number one, is that, okay, what they were actually receiving merited an investigation, you would have to say. And then barrier number two is you have to differentiate an FBI agent who might be overzealous in pursuing this false allegations and overzealous in believing in its veracity. And then you have to differentiate that between, somebody that has malicious intent or criminal intent to say, okay, I'm going to discard the fact that I know this is false so that I can push forward this investigation. And, especially 6 years later, there's not going to be a whole lot of documentary evidence that's new. Maybe there's some government issued cell phones that have some text messages on them, but they're probably not going to get personal cell phones at this point. Those cell phones are probably long gone. So
Well,
Durham
I,
faces a
I
lot of
just wonder.
challenges.
I
Yep.
wonder about this, and it is what it is with the tweet from George Papadopoulos. What, a couple days ago, tweeted that his sources, so whatever that means, that there are agents within the FBI that are turning like crazy over all of this, that are just, ratting people out. And how much do you believe of that from Papadopoulos, being that he was part of this,
Unfortunately, I don't put any faith or confidence whatsoever in Papadopoulos.
Okay.
I don't buy that he actually has any sources, and more than anything, he's trying to market a book, and I don't blame him for that. But in order to sell his book, he has to kind of stay relevant and kind of in the mix. So if you follow
Okay.
his Twitter account long enough, you see basically the same 5 or 6 posts over and over.
Yeah.
So he just keeps retweeting them all out, and he tries to stay relevant. And every now and then he does tweet out something new that might be true, but he's kind of overplaying it a little bit. So and even the comment
Exaggerating.
about the FBI agents flipping, I mean, that's not really true. I mean, Durham's calling some prosecution witnesses that are from the FBI. I think that's what he's referencing, and it's not a true flip. They're just going to testify based on some observations or evidence or whatever. So
Just sad that there are some bad cops in this. Regardless, there are some bad cops. I just have no doubt about it. And the fact that the bad cops, they have put so much doubt and distrust within the FBI, the CIA, all of them. And there are bad cops, and it's a shame. I'm not giving up hope, though. I think I think there's going to be some people get it that we had no idea, and I'm looking forward to that. So that'll be good.
Yeah, that's entirely possible. I mean, John Ratcliffe is somebody I put a lot of faith in. He's been, pounding the table that he's seen some documents that merit more indictments, and I think he's talking about government actors. So that's
And
something to
Kat.
put some faith in. Yep.
So, all right. Well, thank you so much.
Yeah, thank you.
Mm-hmm.
I think the big date that's coming up, and Ryan, you could probably pull it out of your head, but it's the final renewal of the final FISA renewal. And that, without doubt, they knew was bogus. They were presenting false information to the court. Somebody knew. I mean, obviously, it's easy to say they, but there were some people that knew they were putting false information for the FISA court. So sometime in July, I think that'll be a big day. If that goes by, then I think a lot of hope for this stuff goes out the window.
Absolutely. That is the date that I'm really watching for. The fourth FISA warrant was by far the worst. They obviously had debunked a lot of stuff by then, and the first three FISA warrants didn't yield anything. So it's not just the renewal date. I mean, I think King has pointed out you could technically make an argument that you could bring a case through the end of the FISA coverage, which I think is September. But yeah, I mean, even September is only 4 months away. So if Durham's going to bring a case, I mean, it's going to be within the next 4 months, I would have to assume. I mean, you could look at it. There's a July 2018 memo sent to Congress from the FBI in which they reiterate false claims that Igor Danchenko was truthful and honest. You could potentially look at that as extending certain statutes of limitations. I think the comment earlier was about a conspiracy charge. Now, I see a conspiracy charge coming for private actors. Somebody like Rodney Joffe, maybe members of the Clinton campaign. I do see that as plausible. I know Jake Sullivan was in contact with Rodney Joffe. So I see a conspiracy charge there. I don't necessarily see a conspiracy charge coming to the FBI. So I've always felt there might be some process crimes or some crimes around these FISA renewals that I always thought was pretty likely to at least get a couple of those, but I have been moving away from that, and it's hard to say at this point. I don't know. John Ratcliffe says he's got 1,000 documents, and there should be a lot of people indicted. I don't know how much faith to put in that. He's obviously seen the documents that we haven't, but it's getting pretty late in the game, and it doesn't feel like Durham should still be getting new evidence as it relates to the FBI. It feels like he should be done with that by now, but who knows? He could still be chasing down some leads. Rodney Joffe, I mean, that's more on the private side, but he's got contacts throughout the government. He's got multiple businesses, relationships throughout the DOD. He's got a company in Panama. He's got connections through Ops Trust and all these different organizations. You have to pierce privilege if you want to go and investigate this stuff. So, I could see another year passing at least another year before even an indictment of somebody like Rodney Joffe might come. So I don't know. I think it might be a while before we find out, but at least on the government side, I would have to think, next 4 months. Other than Mueller, I mean, Mueller's kind of a separate issue. They wiped out a lot of phones, obviously. We're learning more information as it relates to David Dagan and Manos from Georgia Tech and their assistance that they provided to Special Counsel Mueller. And, the question's out there. I mean, all these text messages that were wiped, do those contain contacts with Manos and David Dagan, or do they have the body of work that those researchers provided, or don't they? And we'll see, I guess. I don't know. Sort of rambling with that one. But MB or Cody, do you guys have anything else before I take a couple more?
We haven't talked much about Rodney Joffe today, and it just kind of occurred to me reading through all this that win, lose, or draw, this jury could walk away going, why isn't Rodney Joffe the one on trial here? Because that guy seems to be just, what's going on with him. And I think some of the stuff that came out about his handling agent in Grasso, and we kind of speculated that it was just a theory, but maybe he pushed all this information through Sussman so that it would get back to him, knowing that the FBI would go to him as the DNS expert. And that would be incredible. I would think Durham would have figured that out by now, but if that happened to be true, that's pretty crazy.
Well, it's really interesting that he brought these allegations, that Joffe brought the allegations to Grasso, apparently the same month that Sussman brought them to the FBI. So that's kind of symptomatic of what we've seen throughout Russiagate, and that they create multiple streams of information flows to create a sense of corroboration, when in reality it's the same people that are doing it. But because they feed it in through multiple channels, it creates this pressure for the FBI to act. So I definitely want to learn more about that. And then I think we learned today that Sussman and Joffe did meet with James Baker on an unrelated matter. I don't recall what it was. I don't know if MB, I don't know if you remember what the topic was, but I thought that was really interesting, in that James Baker knows who Rodney Joffe is. And then Joffe was hiring Sussman to bring this information forward. So it kind of goes to a point that we've raised over the last couple nights. Is this more of a wink, wink, nod, nod situation, in that Baker actually knew what was going on? And I don't know if we'll ever know that, but Daniel, what's up, man?
Hey, so I was just thinking, and this is something that I've thought about a lot, and it was going back to what someone said earlier about Hans, about the FBI being duped, and I agree that's something that I disagree about, because I think that we can separate the Alpha allegations from, let's say, the FISA abuse or the Mueller's team or actions from that, because those were debunked, like we said, very quickly. Didn't really have a large bearing on further investigation, because they didn't go further with it. So I think if Durham decided to charge FBI agents in misconduct, he could say, the FBI knew what it was doing in this sense, they have to check his interviews. He denied it all, and that the Alpha allegations is them being duped. Not by that allegation have no bearing, on the main investigation.
Yeah, I think you made some good points there. I have to agree with that. Let's see. JH, what's up?
Yeah, I guess I had a couple questions about some conflicts that have recently arisen. And one of them is new, and that's juror number 5 in the trial, whose daughter is on a rowing team with Sussman's daughter, and what possible effects that might have later on. I guess it's a fairly small question, but and then the other thing is something that Technofog pointed out today or yesterday, and that is that Jake Sullivan's wife, Margaret Goodlander, is a counsel to Merrick Garland, and is that I guess it's kind of a separate issue directly from this trial, but it seems like that that's just more of this this web that's there, and it's so frustrating. But maybe comments on that, I don't know.
Yeah, you mind if I add on to your question real quick, because I forgot about that. Technofog actually said that she was keeping close tabs on Durham's investigation. I don't know where he got that from. He said there's going to be more on that, but that was just add on.
Yeah, so I know a little bit of the background or the backstory. Techno has shared kind of privately with us. But yeah, that'll be a story. I'm not gonna stomp on a scoop. But yeah, I don't know how long it'll be, but Techno will have a story on that. So I'm gonna leave it there on that one. As it relates to your other question, juror number 5. So this was a story that came out today, or some tweets that came out, and that the prosecution was challenging juror number 5 and asking that she be dismissed from the jury pool because apparently she found out, or she realized at some point, that her daughter is on the same rowing team or swim team or something like that as Sussman's daughter. Obviously, as it turns out, she didn't know that on Monday. She should have disclosed that to the court. But she came on her own volition today and said, hey, I just realized, I just found out my daughter is on the same rowing team as Sussman's daughter. So it was actually a pretty bad move. And the YouTube video from Rob tonight kind of actually broke this down a little bit in the transcript, in that when the prosecution, the Durham team, actually challenged this juror, they did it in front of her, which is kind of a bad move. I mean, they asked that she be dismissed with her right there in the midst of this recess. So with her staying, that you don't know how that's going to play in her mind, whether that would be looked on unfavorably from her. So yeah, that's probably an unforced error from them. MB,
Yeah.
Sorry, go ahead.
I see it as commendable that, that she came forward and volunteered this information when she could have just kept quiet. But regardless, that doesn't remove this conflict. And if I had a teenage daughter, that was friends with the daughter of the defendant, I certainly would not be able to remove that from my mind if I was deciding innocence or guilt. So I don't know. It's just, it seems Judge Cooper just seems like awfully willing to just sort of wave these things away. Although maybe she'll be put into the alternate pool instead of the active juror pool. I don't.
Yeah, once you actually get into the transcript, though, the daughters are not actually friends, and there's actually 30 or 40 rowers on this team, and this, whichever daughter it is a couple years ahead of the other. So, they're not friends. They don't share classes. They're not friends on the rowing team. They certainly know who each other are, but as it relates to today, a juror said they're not friends. So that's pretty important. I feel like obviously if they were friends, it's a totally different ball game. In that case, yes, the juror has to go. But the daughters are not friends in that respect. I mean, she came on her own volition, and if she had malicious intent where she was going to throw the trial or whatever, or rig the trial for Sussman, she wouldn't have brought it up herself, right? She would have just said not guilty or whatever. So I don't really see that it's all that much to worry about personally.
I kind of see it the same way. I would think that this kind of thing has to happen all the time. Just the law of numbers. And probably if you went through everybody that everybody knows on that jury, there's probably more connections that we just, someone hasn't thought of or they don't know of. And, this is DC. If this was in some little town, there's just no way that you're going to get a jury and, have zero connections with the defendant, second hand, third hand, whatever it is. So it seems to me like, I'm not too surprised. I kind of wish one of the lawyers was here to speak to it, but it seems from the outside looking in, it's probably not that unusual.
Yeah, not to beat the dead horse. It is a pretty small issue, but there was a specific question on the jury questionnaire, which makes me think that the question is important. Do any of your family members know any family members of the defendant? Someone posted that question earlier today, but it just seems like the questionnaire made it like a significant question, and not having that information during jury selection seems to be important. But that is, whatever. Yep.
Yeah, I mean, and that's what the prosecution argued, was that if the juror had recalled this or known this on Monday and filled out the form, they would have used one of their challenges and dismissed her. So, yeah, I mean, the judge probably should have removed her, but I don't see it as a big deal. As MB said, you're going to have common connections. I mean, as I do my sleuthing, I found that I actually have Facebook friends in common with people around this investigation that are like subjects of people that I'm looking into, which is amazing because I don't live close to them at all. Like we don't share the same schools or anything like that. We're hundreds of miles apart, and we have Facebook friends in common. So, it's a small world now. You're always going to have connections, I think, more and more between people like that. I think we'll try to take a couple more questions, and I might go ahead and end it relatively early tonight. As I said, I mean, I'm going to be flying out here a couple days and heading to Washington, D.C. So Monday through Wednesday, I plan on having chats and giving more coverage. So I don't want to go like 3-4 hours as we do multiple chats here.
You should see if you could get your way into the press room.
Yeah, I don't know if there's rules on that. I think I saw Leslie was talking about maybe going to the press room, and obviously she's not really press. I mean, she has written a couple of articles, I think, for Red State. So I don't know. I don't know if they'll let me in there or not.
Maybe just hang an ID tag around your neck, and maybe no one will ask any questions.
Yeah, I don't know if they're checking for IDs or what the case is. Obviously,
at least first come, first serve for the main courtrooms.
Yep. Yeah, for the main courtroom. That's really was my original plan, but with people not really live tweeting anymore, I was thinking about trying to get into a position I could do live tweets. So we'll see. Let's see here. Hunter's laptop. What's up? Hunter's laptop. What's up?
Hey, sorry about that. My mic was off.
No problem.
My biggest question is, I'm confused about why Joffe hasn't been charged yet, because it seems like he has obviously violated his. If you're a confidential source for the FBI, there's got to be some sort of rules on how you're telling, your connect what's going on. And to go around that, if it's just me and you talking and you're an FBI agent and I lie to you, I can go to jail. Well, if now you're paying me and then I also go around you intentionally, that seems like a very obvious violation of some sort of law. If it's simply a violation of law to lie to an FBI agent. And so is it possible, or are everybody in the sluice corner thinking that might be the next, like shoot a drop, or am I missing something? And that's my question.
So as it relates to Rodney Joffe, I don't think it's a crime for him to go around like his handler, working as a confidential human source. It's certainly a violation of FBI policy, and that's why he was fired as a CHS. But I don't think it's a crime for him to do that. His criminal exposure relates to primarily the Alpha Bank allegations, that, as far as we know, and that involves a contract with DARPA. There's a potential of a major fraud case being made against him there. Computer Crimes Act, I think that kind of statute comes into play as well, particularly misappropriating his access to gather derogatory information on Donald Trump, the executive office building, his apartments, things of that nature. But moreover, I mean, generally, I think it's a conspiracy charge at this point. A conspiracy charge seems most likely for Joffe. And the issue right now is you don't indict him because at that point you can't really gain additional evidence. So Durham's going to put on the strongest case possible. There's really not any statute of limitations concerns for Joffe.
Because of conspiracy. And the conspiracy is essentially right now, if we think about it, the conspiracy is, if there is a convictable conspiracy, it is currently going on while they are trying this case.
I don't know about that. I I would put the date into 2018 because we know Rodney Joffe was assisting Daniel Jones's Senate investigation into the Alpha Bank claims. He was providing data and analysis to Daniel Jones.
But
is
fighting this case and going against it and potentially lying and perjuring yourself furthering the conspiracy, which furthers the, your time frame when it comes to being charged? And it seems like
Joffe,
right now that's what is going on with him, claiming privilege and things along those lines. If they actually don't have privilege because they're, what is it, work product, and then also they are not, who did he pay? So if you don't pay anybody, how is there any, privilege if you don't actually? I mean, I'm getting down to my mob movie reality of law, but it's like, hey, give me $1 and now I'm your attorney. But if that never went on, then does that not have something to do with it? It's like if every attorney I talk to, I now have privilege when they decide to declare privilege, or am I misunderstanding this?
Well, Joffe hasn't done anything wrong this year, at least. I mean, he hasn't given any testimony under oath other than his civil deposition in the Alpha case. And I don't see any criminal exposure coming out of that deposition. So claiming privilege when, that's kind of a fuzzy topic, that's not criminal.
I guess I understand that. This is a legal situation where you can potentially claim privilege, so we can't hold that against you now. That makes sense.
Well, under a conspiracy statute, it doesn't necessarily have to be a criminal act that furthers a conspiracy. It's what's called an overt act. And an overt act is not necessarily a criminal act, but it's just simply an act that furthers a conspiracy. I don't see anything like that for Joffe right now, but in a conspiracy case, it's the last overt act of any conspirator in the conspiracy.
So I guess my question is, the defenses that are being put forward right now with what Elias did when he essentially set up a mistrial intentionally, he wasn't being hostile to Sussman. He was intentionally setting up a mistrial with those, he was playing the legal rules because he's a smart attorney. He knows what he's doing. So he's setting that up. Is it possible to use any of the things that are being done in terms of the maneuvering with the, calling on, like trying to hold back documents, and then we find out that those documents should not be withheld? Is that ever a potential place to go, you are futuring the conspiracy because we're prosecuting the conspiracy? Now you are doing everything you can to block it in ways that are not, true. You're just making bullshit up. You're saying that it's for one thing and it's not. Is that not a continuance of the conspiracy?
No, I don't believe so.
I think maybe, and this is definitely a legal question, but if he perjured himself in the Alpha deposition in furtherance of the conspiracy, that should be an overt act.
Okay.
If that's my interpretation, but I'm not a lawyer, so we can definitely track that one down because it is a really good question. But I would think that if he had to lie in that deposition to keep the conspiracy going, then that I would think would be an overt act.
And the big problem is proving it's a lie.
And it really comes down to the definition of overt too. So it has, that's got some sort of clarity to it, I guess. But
and there's nothing like that that's going to come out of the Joffe deposition from the Alpha case because he took the fifth on pretty much everything.
Yeah, but I'm talking about his what he did in the trial, where he, that was an intentional act by him, and I don't think anybody that looked at it was like, oh, now Joffe and Elias are enemies, and Elias is coming after him. That was, okay, I'm going to try to blow this whole trial up, and this is the best way to do it. And at some point, it's
Yeah,
like, how do you use the law in your favor? And then there should be a point where, like, okay, now you are obstructing the law by doing these games. But I guess that's just me being idealistic.
Yeah, I don't see anything like that coming out of anything that Elias did. I don't know if there's a creative argument to, make an argument for obstruction on the withholding of documents under false privilege claims that are egregiously not privileged, but I don't see anything coming out of that either.
It makes me
So
want to become
the
an
last
attorney
overt
because I
act,
would love to know how to get in those situations and weasel my way out like Elias did. I think he did a great job. And if I was ever in trouble, I would definitely hire him at this point.
Well,
I mean,
look at how Cooper treated these privilege claims. I mean, the ones that he declared invalid, he was just like, no, yeah, you know what, these are not valid. And it wasn't like, hey, you're in trouble. You know, this was bullshit. I'm calling bullshit on you. It was like, yeah, shooters get a shoot, but no harm, this is how it is. And
yeah,
it's not like he's going.
It was like fair play.
It's like it's a kind of a good old boys club, it seems like, and these guys are all lawyers, and it's like, I'm not gonna make you look bad, and it would have to be something so egregious and so obvious, and that would be enough to get somebody disbarred or something like that. That I think otherwise it's just going to be like, well, you thought you had a case, and I disagree with you, and I'm not going to allow the privilege. And it's like, yeah, but it was bullshit. You know, it was bullshit.
So I'm gonna jump in and ask a question. That the one thing I really love about this whole Sleuth's Corner, and whenever I listen to this, is you guys stick to the facts of the case, and it really doesn't get into politics very often. But then I'm listening to this and I'm thinking, tactically, how do we fight back? And everybody that's been involved in any side of the other argument when it comes to election interference, and if you think those things are all bullshit, then fine. But what all of those people are facing right now is getting disbarred, and they're going after those people. They're going after their licenses and stuff. Is there any appetite on the right to do the same to Elias and all of his friends? Because I think that guy should never practice law again. Like, he seems like a bad actor.
yeah, I mean, I don't know. I can't really speak to the appetite of, conservative movement or anything like that. I don't see anything right now that would challenge Elias's ability to practice law. I think he has some criminal exposure from John Durham, but we'll have to see what develops. And right now I can't make predictions on something that's just not in the body of evidence right now. I don't have anything that would say, well, Elias is definitely lying here, with evidence of the truth. So,
well, either way, Ryan, I appreciate everything you do, and I was following you when you looked like a troll with your Ryan and a bunch of numbers account, and I'm super happy that you're back. And I mean, this is awesome. I think this needs more exposure every time. Last time I got on here, I said, how do we make a podcast out of this? And I think that would be an amazing thing, is one of those NPR style podcasts where you've got like people talking in the background and they've got all that stuff, because this is a story that needs to be told. And if it's produced correctly, I think it can be told to more people than we all understand. And it definitely needs to. But I'll get out of here and I'll listen to all these other things in the coming weeks with this trial. And I hope it keeps going the way it's going.
Yeah, I appreciate those comments, and appreciate that you followed me back then. I've actually been banned from Twitter a few times. I've had a few different accounts. I've never done anything egregiously wrong. I don't think I've ever actually violated their terms of service, really. But I had an account that was banned kind of during the Great Purge of 2021. I never posted about the election. I didn't post anything controversial. All I really did was retweet people for the most part.
Well,
but
wasn't the last
at one
time
point
you posting a FOIA, like documents from your FOIA, which is literally public information?
Yep.
Yeah, that's bullshit. I think we can
Yeah,
all
it
agree
is.
on that.
And I appealed that 3 times, and I told them explicitly that these were FOIA documents that were lawfully obtained, and therefore it's public information and meets their terms of condition. And it's like there's no human there. It's like automated. I couldn't even get like a real person to actually respond to what I was saying. So that was pretty frustrating.
Well, I think the rebrand is a way better brand name. UndeadFOIA is way better than Ryan with a bunch of numbers. So you live and you learn, and you're better for it now. And
Well, I
keep watching
appreciate
it.
that. When I created the account, that was like just whatever randomly generated when I signed up, because I didn't think I was going to be able to create the account, because when I had tried before, it like automatically bans you because it's associated with an IP address. So I didn't think I'd actually create the account or be able to be on long. So I just had like one tweet in mind, and I tweeted that out, and then sure enough, I was able to keep the account. So that's why I had all those random numbers. But
Well,
yeah, I appreciate it, and
I
I don't
appreciate
know
your
about a
service. I
podcast,
appreciate your
but
service, and I honestly do think a podcast where you guys, King, FOIA fan, like just, I mean, if anybody can ever get Technofog to talk, that would be amazing. It would be,
I've heard him talk.
well, yeah, in public. It would be an amazing podcast, and I'd be hanging on tight, and I'd be on the Patreon and everything like that. So I appreciate what you're doing, and I'm listening in, and I think there's a lot of people out here like me that are listening and just watching, going, "Holy cow, how does this happen?" And
Yep.
you're doing a good job, man.
I appreciate that.
All right, bud. I'm out.
Alrighty, thank you. Let's see here. Not Roger, what's up? Not Roger, what's up?
Yeah, thanks for letting me speak. Just with regard to that juror thing, I don't know if you've read Jonathan Turley's recent articles. It's kind of interesting, tale of two trials, and he points out the difference in how Cooper is treating this situation versus, when conservatives are being prosecuted. It's kind of interesting. But I had posted a tweet on after Ship had talked about potentially bringing in Durham will bring in evidence from the communications that Sussman had, and it brought up a question in my mind: were any of those pieces of evidence covered in the limine pre-trial motions, or was that limited to other stuff? In other words, are we going to see some significant evidence that may sway the jury towards conviction? So that's one question. The other one, kind of tangential, is, Seago and Elias both testified with the grand jury, and you would have thought that they wouldn't have been brought to the trial if their grand jury testimony was the same as what we heard in the trial. And I know even Ship kind of was a little bit kind of confused as to why we even had that. Just wondering what you guys' thoughts on that are. Finally, the Monaco shenanigans on cyber prosecutions, will that have any impact if we find that, Jaffe was spoofing data, or is that going to affect something else?
Yeah, so I got a little hot under the collar on this one. So Department of Justice put out some updated policy in that if you misappropriate access, but you're acting in good faith for like security research or something like that, as long as you're acting in good faith, they're not going to prosecute you. even if you abuse your access or basically hack somebody. So yes, I think that has the potential to impact John Durham. I was thinking more specifically of the EOP contract that Rodney Joffe had. So Joffe was authorized to look at the White House data. That related to a 2015 hack. And after that, Joffe got access to monitor those data streams. Now, what he ended up doing was he was researching that data stream to look for derogatory information on Donald Trump. That's one of the things that he did. So that would seem to strike at the heart of what this new guidance from the DOJ is going to rule out, because it's going to be really hard to prove that Rodney Joffe was acting in bad faith when he started looking for derogatory information. I mean, Joffe's going to be able to say, well, I had a security concern, or, something like that, and that's going to provide him some cover. And I don't know, I don't know if that's going to impact John Durham or not. That's one of the things that I saw as a potential predicate offense of a conspiracy charge, was like a computer crime, which is a separate statute, but is considered a predicate offense for a conspiracy. And it's going to provide a little bit of cover to the people at Georgia Tech, I think, or some of the other people that are around this case. More specifically, though, I think it relates to Rodney Joffe. So I don't like the ruling at all, or I don't like the policy. I think it's my opinion that it is directed at John Durham, and I hate that. So I forgot what your first two questions were entirely. I don't know if you want to repeat those.
Yeah, just the evidence that Shipp had said might come into the trial related to Sussman's communications that tend to support the charge that Durham's bringing. Was there stuff in Limine that prevented that type of evidence from being introduced? Sussman's communications, or do you recall?
Yeah, so the motions in limine, the portions that were granted was excluding any communications that Sussman was not party to, with
Okay.
and there was just a handful of exceptions, like the emails from Fusion GPS telling certain reporters to do stories on the Alpha Bank allegations. Those are coming
Right.
in, but other allegations that were going to support this joint venture conspiracy, those are going to be excluded.
Okay.
So that was kind of central issue there.
So the final question I had was, when we were reading about how John Durham had the grand jury and that they've locked in people's testimony, so you don't have to worry about Baker or somebody coming in and this totally, saying something different. But that brings up a question. They had Elias and Ciego in the grand jury, and if Elias said he didn't remember in the grand jury, why would they bring him in again? Or if he didn't say I don't remember, how could he change his testimony? Same thing with Ciego. It's a puzzle to me that they would put them in the trial if the grand jury testimony was as weak as what we saw in the trial.
Yeah, so I think there's obviously some portions that were not helpful to Durham, but I think those witnesses were brought in for very specific purposes. So Elias was brought in to talk really about the billing records, and also he established the fact that the Clinton campaign had knowledge and interest in the Alpha Bank allegations, and he also confirmed that for the court records that they hired Fusion GPS. So that's important. And then from there, we have Laura Siegel from Fusion GPS confirming that the Clinton campaign, they were working on the behest of the Clinton campaign to advance these Alpha Bank allegations. And she also testified to a very specific meeting between herself, Sussman, Elias, and Rodney Joffe, in which Alpha Bank allegations were discussed. So they didn't go down the rabbit hole because they're not real favorable witnesses for Durham. But to get those points in is going to be important because it goes to the heart of Sussman's lie, in that he's saying he was not representing the client. Well, between these two witnesses, you actually can confirm that not only does he have a client, but here are the actual specific clients. It's the Clinton campaign, which is established through Elias, and it's Fusion GPS, and to some extent Rodney Joffe, which Sego was actually able to introduce into evidence as well. So that's the whole reason that those two witnesses were brought together, because now there's really no question that Sussman lied, and the case from here out is just about materiality.
So you think the trial's gone the way Durham was hoping it would? It seems from some of the backseat driving from legal people like McAdoo and others that, the prosecution hasn't really necessarily done a good job dramatically in terms of who goes first and the questions and making sure the jury doesn't get bored, all of that stuff. Do you think that that it's going the way Durham hopes?
Yes, certainly today and yesterday, Durham has had a couple really strong days. You get a better sense in actually reading through the transcripts, but the questions flow really well. They're managing the witnesses really, really well. I did read the thread from Leslie McAdoo Gordon, and I think she had a lot of valid points on day one. So day one, I think, was a little bit more disorganized. I don't agree with them putting on Special Agent Martin, who's the DNS expert, as the first witness. I think she raised that point, and I had some concerns with that myself because they didn't really transition into a data-intensive witness list, right? So they start off the trial talking about DNS terms and technical stuff, and then they really don't go into the data all that much, and they're actually limited in being able to challenge the data. So Special Agent Martin was really brought in just to define some terms, but that's kind of it's not an ideal way to start off a trial, in my opinion. I mean, I think Leslie brought it up, and I would agree. I think you want your strongest witness to start off day one. So I wouldn't, I don't know. Durham's been doing this, and I haven't. So, I trust Durham in what he's doing, and he's had a couple witnesses that are uncooperative, but I think he has actually managed them really, really well. And Baker today was absolutely a phenomenal witness for John Durham. We're going to hear more from him tomorrow, but Baker had the most important testimony of this entire trial today, and the government got everything they needed out of him.
Yeah, that's how I saw it too. Well, thanks for your feedback. It's given me a little bit more optimism after getting kind of crushed by some of the feedback, the tweets I've seen,
Well, it's really hard to get context from tweets, and
Yeah.
you can't blame them. I think they do the best they can, but your fingers get tired, and it's really hard to tweet out sentences in real time and at speed. So I wouldn't
good luck,
be too hard on
with
them.
you trying to do it.
I don't know. Yeah, I'm not going to promise anything. I might.
Okay.
I'm going to take
And
some notes.
If you're a betting man, where do you stand on the question of whether he'll be convicted?
Yeah, I would say 85% conviction.
Ah, that's good.
Yeah, I feel pretty strongly. I'm a little bit concerned about a hung jury, but there's really no potential of an acquittal. I don't see all the
a Tamika Hart type situation.
You
know who that is, right?
Yeah, I do.
Yeah. Yeah. Okay. Thanks a lot. Huh?
Yeah, thank you.
Yeah.
Boy, I have been talking way too much on this one. I wish we had MB. I don't know if you want to jump in. Maybe you can take 5 or 6
minutes. Crazy. I'm a little bit more pessimistic than you. If you want me to rank it, I guess I'm probably 50% acquittal, 50% hung jury, or 49%. I'll leave 1% for conviction. It's a DC jury, and I, you know, I've heard King talk a lot about uh, juries and how it's impossible to know what's going to happen. Figuring out what a judge is going to do is one thing, and you put 12 or 13 people in a jury room, and if you get somebody in there that's, like we talked about, kind of an activist and just leads them down the primrose path of, hey, remember how much we all hate Trump, and let me go through the evidence and tell you what I think. And I mean, you can see that on Twitter. There's plenty of corners where they're like, this whole trial's a sham, and I'll prove it to you. And I'm sure everybody knows Marcy. Empty wheel, they can go over and she'll lay out a really good case for, if you were, a civilian that walked into this, you would go, yeah, she's absolutely right. And you'd have to know a lot to say, wait a minute, no. There's a lot of bullshit happening here. That's why I think this corner is really important. And I think what Ryan does is awesome. And everybody being here is, you're probably like me. You're going out and educating other people and talking to your friends and family. If it, trying not to be a bore and making every conversation about, oh, did you hear what was going on in the Michael Sussman trial? But I've talked to a lot of people, and they are interested, and it does turn them on that you can explain it in an intelligent way and lay out the facts for them, and then they can go look themselves and find out, yeah, I think that's correct, that this is true. So we'll see. I think that definitely it has been a roller coaster. Today and yesterday were so much better than the first day. If it really kind of depends how the defense still has their case to lay out, and we'll see what they do. But I think the next couple of days of the prosecution will be solid too, because there's definitely some stuff coming in that's going to be really, really difficult for the defense to get around. If that, I assume that transcript from the House Select Intel Committee is going to come in, and that's damning. I mean, it seems like he equivocates, and some people are arguing that he kind of equivocates about whether he was tasked by his client, but his equivocation is worse, because he says, well, I was sitting in a room with my client. We discussed his wants and his needs and his objectives. We came to a conclusion. Then I went out and did what he wanted. It's like, that is the definition of a lawyer lawyering, of taking up your client's being that person's lawyer. So I assume that'll come in, and that's pretty much going to be a game, set, and match for whether he lied. He definitely lied. It's the materiality is going to be the question, and if this jury just decides we're not going to convict, we're going to nullify, that's always been the ace in the hole for the defense, that they're just not going to do it. So I guess we'll see.
Yeah, I mean, I think the more the jury discusses it, the worse it gets for Durham, because it's important to have all its context about Fusion GPS and the Clinton campaign's out there too. But if they keep this simple, and especially they really emphasize some points in their closing arguments, it becomes a really simple case. I mean, it's just a false statement case. I mean, there's not a whole lot going on here. The lie is not going to be in question, and Durham can make that point really simple. The lie's not in question. Sussman lied. Point number one. So then point number two is just materiality. Did it impact the decision? And that's the question they have to pose it as. If they go off in closing remarks and they're outlining Fusion GPS and Clinton and motivations and stuff, then you give the jury a lot to talk about, and they have to go through all this evidence, and then they have the potential of going off track. But if you keep this narrow and focused on the false statement in closing remarks and really narrow the case back down, I think you get a much higher likelihood of a conviction. It's a false statement. He lied. And this is why it's material. 1, 2, 3, 4, 5 points, done. And you give that to the jury, they go back. There's no way that they should be able to quit. Maybe there's a hung jury, but I would lean towards a conviction. So let's see here. JH, I'm going to give you the last word, and then I think I'm going to wrap this one up. JH, what's up?
I was just going to add a little context to that DOJ guidance sort of policy thing that they did here today. on computer intrusions, and it would just, anybody that's sort of interested in that topic should take a look at the case of Aaron Swartz, who was an MIT student that basically was driven to suicide by the Department of Justice for accessing documents in good faith. And to see them, this was 2013 that he killed himself, but to see the Department of Justice just sort of flippantly change policy like this is outrageous, in my opinion.
Yeah, I'll have to read more about that case. I'm not too familiar with it myself. So, yeah, I would advocate for there being a presumption of bad faith. Like if you go outside your authorization and do more, it seems like you should infer bad faith there, and that should be the standing policy. They should have went the complete opposite way with this policy change, and yeah, I'm really concerned about it. So,
yeah, Aaron Swartz was basically faced with 35 years in prison for downloading public documents that he was given access to. And, it seems very likely that this DOJ guidance is geared towards Rodney Jaffe and all his crew who were doing stuff that they had legal access to. And to see them just sort of, disregard history and do this, I'm really hot about it.
yeah, I was pretty fired up about it earlier. I mean, I really hope that gets picked up by some congressmen, and they put some pressure on it. And I hope Durham responds if they reach out to him, because it sort of falls at Durham's feet. I mean, if Durham says yes, there's a potential I'm pursuing a case that is going to be relevant to this policy, then you see it for what it is. It's brazen political interference by the Biden Department of Justice, and it seems much more targeted at what Durham is doing. And Durham's got to say that. We can't get to a point where Durham's done, and then we're finding crimes and we're finding evidence that stuff should have been prosecuted, but policies changed, or Durham didn't get the authorization or the support that he needed. Like, if there's going to be an issue like that, we need to know about it now. I think Hans makes the point, and I'll never disagree with Hans on anything, but Hans makes the point, well, Durham's got like the skeleton staff, and Garland's not going to give him all the help that he needs to bring all these prosecutions. And I totally disagree. I mean, there's just too many political calculations involved if Durham asks for help. Like, I don't see it likely that Garland's gonna turn anything down and risk that blowing up in the media and being the focus of so many inquiries. So if Durham asks for something and Garland shuts him down, I mean, that should be a major story. So it's really on Durham, and I don't want to hear from Durham in a couple years that he's blown by statute of limitations just because he didn't get all the help and support that he needed. So
he seems to be a pretty quiet guy, but I'm very much looking forward to the congressional hearings where he's asked the question, did anybody ever interfere with your investigation or deny you any access to any leads that you were pursuing? And we saw that all over the place with the Mueller investigation. And what bugs me is that if that is happening and Durham remains silent, it just reinforces this double standard that exists in the justice system. And that's one of our biggest threats as a country right now, in my opinion. But yeah.
Well, that's a really good point. If you look at the way that Mueller treated his people that he got to flip, I mean, he's going to drop 20 years in prison on them. He's going, he's kicking their doors in the morning and scaring their families, and tipping off CNN to put the cameras here because we're gonna perp walk this guy. And
he charged Roger Stone for lying to Congress. And here we've got testimony from Sussman that clearly he lied to Congress.
Yeah, where he he does not seem to be playing the kind of hardball that, and you know what, maybe that's right. Maybe, saying I wish that we played dirtier, that, that Durham would throw elbows like Mueller did. And I don't know that that's right either, but this double standard is terrible. And it's really a detriment to our country. And it's, if one side just is so self-righteous, they think that that the ends always justify the mean, we get serious trouble.
I agree with that.
Nothing worse than, losing while standing on principle,
Yeah, I think that's good points, guys. I think I'm going to go ahead and end the chat here. I appreciate everybody coming. I don't plan on doing one tomorrow, I don't think, unless something major pops up. I'll be packing and getting some stuff ready. So I'm gonna do my best on Monday to plan out a chat. I'll probably schedule that. I'll probably plan on doing at least a quick chat every night, Monday through Wednesday, and I'll be able to be in the courtroom and see what's going on a little bit. And I don't know if that'll help with figuring this out or not, but I'll do my best. And yeah, so I'm gonna go ahead and end it here. Thank you to all our speakers. Thank you to everybody for coming, and everybody have a good night.
Night, everybody.
Thanks.
See you guys.